My mother-in-law is got some bad news less, and she has a sizable inheritance that she took on from her parents.
Okay.
And she has everything under beneficiary rights. In other words, her two daughters are half and half beneficiary on all of her IRAs, her bank accounts, and what have you. I'm just wondering if this is going to be substantial enough to bypass probate, or is that going to cause an issue still?
Well, Rob, you are on the right track that you want to avoid probate when your mother-in-law passes away. The good news is that typically an IRA, retirement accounts, life insurance, annuities, anywhere where you get to name beneficiaries, you can assume that that asset is not going through probate. So if she has IRAs and she's named her two daughters as the beneficiaries, they're not going through probate. When she passes away, your wife simply shows the IRA company her death certificate. They'll turn the money over to her. So, Rob, what about her bank accounts, her checking, savings, CDs?
I'm sorry, you broke up a little bit. What'd you say?
What about her bank accounts?
Yes, they're all benefit. There's my wife is actually on as a co-owner of the bank account, so she will be the one that disperses at 50-50.
Okay, and what about what about a home, real estate, Rob?
She owns it outright.
The mom does.
Yes.
Okay. So the home is going to go through probate, Rob. So if we want to avoid probate on your home, we have a great tool for that called a ladybird deed. And so, Rob, I'd like for you to call my office next week, and we can talk about doing a ladybird deed for your mother-in-law.
Fantastic. Okay. And then I have a quick question, and it's off the wall. So if you can't answer it, I understand.
All right.
My sister-in-law has borrowed several thousands of dollars from my mother-in-law, and she said that she would just take it out of what her inheritance is. But I'm not sure that she's documented anything. So is there something that my wife, who is concerned about this, can do to make sure that that comes out of her portion of the inheritance?
Well, first of all, in my perfect world, mother-in-law would do some kind of writing saying, hey, my daughter, Betty, owes me $10,000, and I'd like for it to deducted from her share. All right? So nobody has to guess that this was mom's intention and this is the amount due. Now, Rob, you told me that your wife co-owns the bank accounts with mom. The other daughter is not a co-owner of those accounts. What that means is that when mom passes away, that money literally belongs to your wife. It is hers to do with as she pleases. She would not be obligated to split it up with her sister. If your wife wants to say, okay, I will split it, but I'm going to back out $10,000 first, hey, there's not a thing that the sister could do about it. But to preserve our family unity, that's why I really want mom to have something in writing saying that this money is owed and what the amount owed is.
All right. Okay, good. All right. Thank you very much. Appreciate it.
You're welcome, Rob. And feel free to have your mother-in-law come see me next week. We'd love to help her. Folks, we are all about helping people to avoid probate at the Olsen Law Group in Orlando. We do offer a free initial consult to talk to you about avoiding probate. Even if you've got an existing will or an existing trust, bring it with you. We'll go through it. We'll make sure that you are taking steps necessary to avoid probate. Call me, Attorney Tom Olsen, or Chris Merrill at the Olsen Law Group in Orlando at 407-423-5561.